Hello, beautiful butterflies. Where's the music? Well, this episode is going to be a little bit different. This is actually episode 220 of the Flying Free podcast, but today we're going to do something I've never done before. And that's share an episode that aired about 3 years ago and is just too good not to reshare for our growing audience. In this episode, Wendy Hernandez, who is a family law attorney in Phoenix, talks about how to prepare for your divorce case. You'll find out why the fear of losing your kids is based on lies and misconceptions, the kind of documentation and questions you should have before or while you are using an attorney, including how to find a good one or deal with a bad one, and how empowering divorce can be as you set boundaries for a new life of hope. Wendy has tried over 1,000 cases during her 27 years as a litigator, so she speaks from extensive experience. Next month, in the Flying Free program, I'm reteaching a course called Divorce Basics. And if you want to get in on that course, as it's taught live, and you're not already a part of the Flying Free program, then I encourage you to get your application in now so that you can be with us for this course. Just go to joinflyingfree.com. You'll have access not only to this course as I'm teaching it live and the replays, but all of our other courses as well. In addition, a weekly coaching and community and support within our private forum of hundreds of Christian women who are going through the same things you're going through in their marriages. In my program, we don't tell women that they should get a divorce, but we do support women in their own autonomy and ability to make healthy choices for themselves. And for some, that means they're going to want to get a life-saving divorce from their abuser. This course is just one of the ways that we can help guide them on their way. The cost is only $29 a month, and you can cancel at any time. So head over to joinflyingfree.com for more information and to complete an application. Okay, without any further ado, here's our episode. Hi, this is Natalie Hoffman of FlyingFreeNow.com, and you're listening to the Flying Free podcast, a support resource for women of faith looking for hope and healing from hidden emotional and spiritual abuse. Welcome to episode 84 of the Flying Free podcast. Today, I am really excited to introduce you to Wendy Hernandez. She is a Phoenix family law attorney. She's a divorce coach, founder of the Hernandez Family Law Firm, and creator of this amazing YouTube channel that I hope all of you will go and check out. It's called Command the Courtroom. She's got bazillions of videos on there on every subject that you could imagine when you're going into a situation where you're going to file for divorce and you're hoping to get as much custody of your kids as you want. Plus, she has online programs that we're going to talk about at the very end after you've heard all of the great things that she has to share in this podcast episode. Now, Wendy is coming at this with a lot of experience. She's tried over 1,000 cases during her 24 years as a litigator, tackling every type of family law matter from divorce to child custody and everything in between. I love how she not only helps her clients, but she also helps women who are representing themselves to feel competent, confident, and comfortable in the courtroom. So welcome, Wendy.
Thank you, Natalie. That was a wonderful introduction. I'm happy to be here.
I'm so happy to have you. So I found you a few years ago when I was in the middle of my own custody case, and your videos helped to calm my fears. From the standpoint of someone who doesn't know anything about court, my only experience was what I had seen on TV and in the movies. And that it just felt so scary. Plus, divorce feels scary. The whole thing, so let me just tell you this. Our audience is women of faith who are in emotionally and spiritually abusive relationships, okay? So a lot of these women, they've been kind of beaten down for many, many years, and they don't feel really good about themselves. So the thought of having to haul themselves up and go to court and face all of the things that they have been facing over the past years, but do it in front of a judge and in front of 2 attorneys, and also have their soon-to-be ex sitting there, and they're fighting for the most important thing in their entire lives, which is their children. That's usually that's when it gets really, really scary. So I just wanted to let you know that, because the kinds of questions I'm going to be asking you are from those women coming from that type of perspective.
I hope I can help. I'm sure I'll be able to.
Yeah. I think so too. One of their concerns too is that it's not that they don't want their children to have a relationship with their father. It's just that because of the dad's propensities to be emotionally abusive, they don't want to leave their children alone with him. So they're scared about sharing custody because they're afraid of what their children will go through if they're not present as a buffer. And then there's this added layer for my audience, because many of these women are also being actually threatened by their friends, family, and church support system, because these are women of faith, that they're not going to support them if they file for divorce, because divorce is not allowed for a lot of these women. So, and I've even known women who've had friends and family get up in court and testify on behalf of the abusive husband in order to, and which makes the mother seem crazy and selfish, which she's already been told that she is for so many years. So it's just this added huge trigger. And some of them feel pretty hysterical about this is never going to work. I'm never going to get my kids. Some people have this irrational belief too, that they're going to lose their kids and not be able to see their kids at all, which I think is, in your experience, how common is that?
Well, in my experience, it really takes a lot for a person to lose their children. My experience is that judges really want both parents involved to the fullest extent possible. Yeah. And it takes some, severe drug abuse, severe mental health issues that are not being treated, severe domestic violence on one part of the party, maybe incarceration. These are the types of things that a judge is going to want to see before a judge literally disallows contact between one parent and the children. And, I've had cases where all of those things were present, not the incarceration, but the mental health issues, the domestic violence, and the substance abuse issues. And even in that case, a judge said, I think the children need both parents, and these factors are present, but I'm going to do everything that I can to make it possible. So I'm thinking, Natalie, for your audience, they're women of faith. I don't know how often all of these issues are present, or that they're the ones who are suffering from the drug abuse, and it could be possible, but even with those things present, if you're taking steps to make it better, if you're seeking rehab or something like that, and especially with the mental health issues, because these are present in a lot of cases, especially if you're a victim of abuse, but if you're taking care of the business and getting treatment and following your doctor's recommendations, then I think it's really difficult for a judge to rip custody away 100%. So hopefully that alleviates some fears on the parts of your viewers. And the fears are real, and I understand where they're coming from, because you're so used to being victimized by your ex or soon to be ex, and this gaslighting has probably happened, and they've led you to believe, that you're this person that you're really not. So I understand where the fear is coming from, but I also want to say, you got to recenter and kind of examine and look within and say, who am I? Really, who am I? And once, they are firm in that, which is going to take some time after years or months of abuse, then you have to proceed knowing who you are and knowing your truth, and knowing that, if you show this truth to the court, that it'll probably be okay.
Right. Okay. That's good. That's really good. What do you see as the biggest mistake that, we'll say women, I was going to say people, but since my audience is women, what do you think is the biggest mistake that women in this position make when they're facing a custody battle? How can they avoid that mistake?
Yeah. So I think one of the biggest mistakes that I see being made is allowing the bullying to continue and feeling afraid that, if you're standing up for yourself, that you're not being a good person. And just because you are making a stand finally, for the first time in forever, doesn't mean that you're a bad person. It means that you are, fighting for your life, number one, and fighting for your children, number two. Just because you're being strong, doesn't mean that you're bad or that you're going to go to hell. It doesn't mean that. It means that you're standing up for your rights as a human. So I see people or women really living into their fear instead of living into who they really are. That's the problem. So, walking into divorce is terrifying. It's terrifying for me. And I've never been through a divorce, but I go through a divorce every time I help a client go through divorce. And it's scary for me. So I understand, you come from this place of fear, how it's a big step to go to this place of strength, but it doesn't happen all at once. And it starts with little steps every day or every time you talk to your attorney or every time you go to prepare your case, and with each little step, then progressively, you will become this person really that you are and that you have the potential to be, but you have to live into that instead of living from the past or, living in the past, which is fear. So I think really being strong, not allowing yourself to be bullied, having firm boundaries with that ex, setting those boundaries, communicating those boundaries in a constructive way, rising above the unhealthy communication that will happen and that probably does happen, excuse me, and, just communicating as to the issues. So I think just really, to get back to your question, I'm sorry, that was a long-winded answer.
No, this is great.
Yeah, the mistake is, I think, just living in fear instead of really stepping into strength and allowing that abuse to happen, continue.
Okay, so what if, here's the opposite idea that I've actually seen. So sometimes what happens is they become empowered enough to get out of their relationship and to file for divorce. And there's a lot of pent up anger over what's happened to them as they look back. And now they feel like they're in a cat fight. And so they might even, now they're saying their truth, they're speaking their truth, but sometimes it can feel like they're vomiting. Okay. Mm-hmm. And I'm just wondering, as far as demeanor in court or even working with your attorney, how can they temper those feelings so that they don't come across as hysterical or defensive or like cutthroat? Like, now I've got to get my kids back and my husband can't have them at all. And, he's going to ruin their lives. And I know that can kind of backfire on them as well. So can you talk about that a little bit?
Yes. So, I think first off, when somebody's going through a divorce or any huge, traumatic experience, they need to process those feelings. There's the stages of grief, and the place to process them is not on the stand in the courtroom at your custody trial. And, not. And so a lot of what I do is counseling with my clients, but I'm not a therapist. So I always tell my ladies, like, if you can get a therapist, that would be helpful. If you can get a counselor, that would be helpful. If you're not able to do that, maybe somebody from the church, a clergy member, somebody who can counsel you and help you process those feelings. And, a lot of what happened during the relationship is probably going to be relevant during the divorce and custody trial. The judge has to look at the best interests of the children, and if there was abuse happening, whether it was financial, emotional, or physical, the judge is going to want to hear about that. So, it's a fine line between vomiting in front of the judge, but also sharing with the judge the information that the judge absolutely needs to know. So, I think emotion is important because there's a disconnect when women go on the stand and they seem like, there's no emotion, yet they're saying this abuse happened. It doesn't add up to the judge.
Yeah.
So some level of emotion definitely is appropriate, but falling apart on the stand probably is not helpful. So they have to balance that.
Yeah.
And I think the counseling prior to court happening and maybe even working with somebody like a divorce coach or something like that would be helpful. But also really when you're on the stand talking about the facts and referring to the documentation, if there is any, text messages and emails are powerful documentation. I've heard people say, or judges say the person with the most documentation wins. That's not always the case, but documentation is great. But as much as possible, removing the raw emotion from it. Because when you get out of a divorce, you're really raw, right? And hurt.
Right.
And maybe the further away that leaving the relationship gets, the emotion's there, but it's less raw. Does that help at all?
Yes, it does. Okay, so speaking of documentation though, so the women that are in this audience, some of them have also dealt with physical abuse, but the majority of them have dealt with mainly emotional abuse and spiritual abuse. So, where the Bible is kind of weaponized against them to control them. There's a lot of lying, gaslighting. They're told things didn't happen that did, or did happen that didn't. And they are a little bit sideways, as far as like what's real and what isn't. A lot of them will ask me, what documentation do I have? I wish my husband would hit me so that I would have something to show that he would never hit me. He's never hit the kids. He just criticizes us. He just, I won't go into all of it, but
right.
What kind of documentation can those women put together to prove emotional abuse in court?
Well, it's difficult. And probably in that situation, the best documentation that they're going to get is their own documentation that they create as this is happening, or if, they're out and it's no longer happening, really sitting down and writing about it. So if they end up in court at that time, they have a good memory about what happened, because it's hard for me to remember what I did last week or what my husband said to me last week, or,
Yep.
So if they can write it all down, it helps keep it fresh. That's something that they can refer to. But also I think the writing is good at helping them process things. And maybe, with the grieving process.
Yeah.
So, and I don't want anybody to think if you don't have any documentation that you're totally dead in the water. That's not what I'm saying at all. If you have documentation, that's really good. But if you don't, that's okay, because documentation is not the only evidence that a judge considers at trial. Other types of evidence are witness testimony. And when evaluating a witness, the judge is going to determine how credible that person is. And one of the things, for example, that a judge will look at in deciding credibility is a witness's ability to remember important details. So this is what I'm saying with the journaling. That will help. And I personally think, when a witness can get on the stand and they, remember the shirt that their ex was wearing, or where they were standing in the kitchen when this happened, or where their children were, these little details, to me, that shows that a person is more credible as opposed to just kind of glossing over things. So,
okay.
Yes.
So along those lines, one of the things that I did was I started for 2 years before I filed, I started documenting all of the things that he would say and do. And it helped me actually to see patterns. So a lot of Christian women, there's this verse in the Bible that says, don't keep a record of wrongs. Love doesn't keep a record of wrongs. So a lot of those women will be like, well, I can't keep a record of wrongs. So they won't write things down, and they'll purposefully go into, their brain will go into shutdown mode, and they won't remember a lot of stuff. So what I tell them to write stuff down, every little detail down that happens, for as long as you can before you actually file for divorce. But so I did this, and what I found is that there were patterns of behavior. So I put together, I never ended up going to court. We ended up solving it in mediation, but my document had the main, 5 or 6 main patterns of behavior, along with a few examples. And that's what I brought to mediation, and that was helpful. And then the other thing is, I was thinking, one thing that I can show is lack of response to emails, or lack of response to everything. And so that's what I've been saving. I'm just giving this for those of you who are listening as an idea. You can also document things that are not happening, that should be happening. Like that he didn't show up for something, or that he was supposed to, or he didn't keep a commitment, or just those kind of negligent kinds of things. He's not communicating with you when you're talking back and forth on Our Family Wizard about, who's going to pick up the kids. So, those are, but I feel like it is more of a stretch for those of us who are dealing more with emotional abuse to actually find those really substantial, obvious, glaring examples of issues.
I agree. And I love what you did, Natalie. And, I've had clients do something very similar to that, creating charts for me with the examples. And, I think that's helpful. It would be helpful to the court. And, you're talking about the failure to respond by the husband or the ex, and that's big. And I will tell you that many, many years ago, I represented the husband. And in a case like this, like we're talking about, and he didn't respond. And that is exactly what mother used against him. And that's exactly what won her sole custody of her children, because the court said, joint custody requires co-parenting, and father has shown a failure to co-parent by his inability or unwillingness to participate. So therefore, I'm not giving him joint custody. So I think, that's powerful to show the lack of what is happening, or the rude responses that are happening, or, not showing up. Somebody who's saying, I want all of this parenting time, I want equal time, yet when they get it, or they get it during temporary orders, they're not exercising it. They're not making those phone calls when those phone calls are scheduled, or the Skype calls. So that's really good. Those are good points that you brought up, Natalie.
Okay. All right. So it sounds like there is hope then, because that was one of my questions. Is there hope for women who are just dealing with emotional abuse, that they can get as much time as possible with their kids? Should they just resign themselves to probably just getting 50-50, or is there hope that they can get more than that? What are you seeing across the board?
I don't think that anybody should resign themselves to 50-50 if they don't think that it's in the best interest of their children. By the same token, and you already mentioned this, I think that it comes across as very unreasonable if, someone were to go into court and say, I want dad to have 0 time, because the judge then would think you're crazy. Right. And maybe that's what, you think, but unless there's something really crazy happening, that's probably not going to happen. So you have to balance what you want against what the law says. Okay. Because in these cases, people usually don't get 100% of what you want. And that's part of the reason divorce is difficult. And each case is different. You have to look at the facts of your case and decide what's best for your children in view of the circumstances. So, if you have a husband who is married to his work and working all of the time and abusive on top of that, that may be a really good reason to ask for every other weekend. So not one size fits all in these cases, and you have to look at the facts. And there's, if you're not, there's always a way. You can be creative enough to make a good faith argument to the judge about what you think is best for your children. And if somebody's telling you can't, then I don't think that they're thinking outside the box or being creative enough. That's my thought on that.
A little bit ago, you mentioned that you have your clients fill out forms that will help them to document things. I noticed that you had a course. I think you have more than one course that's available. And plus you do individual divorce coaching. So
yes.
I wanted to talk about this at the end, but I actually decided that I want to talk about it right now. So, because that would have been really helpful for me to be able to have like someone guide me through what I need. I had to kind of make this up as I went along. And I'm more of my personality is more like, I can do this. And I'm constantly thinking about it. But a lot of the women that I work with, they're like dead in the water. They're just so exhausted and wiped out. They don't have the emotional or the brain bandwidth to come up and do this stuff on their own. They need help. They need like that kind of extra guidance. So why don't you tell us more about what you would offer to maybe a coaching client versus what you offer in your courses?
Yes. So I have several courses, and the one that's been really popular is the 21-day child custody challenge. And really what I do is I lead my clients or the people who are taking the courses on the same journey that I go through when I get a case. And my steps that I take to resolve the case. Now, the 21-day challenge only covers through a certain point, but each day there's a little video that I share with them and a prompt. And, so the amount of time to consume each day's content is less than 10 minutes. Okay. But the real work is, for the person who has the custody case or the divorce, and really, it's going to require work, but I'm guiding them and telling them, okay, step 1, this is what you do. Step 2, this is what you do. Step 3, this is what you do. So the 21-day challenge, we do that for 21 days.
And that sounds like it would save you money in working with your own, even if you were working with your own attorney, because you would already have a lot of your ducks in a row.
Yes. And there's been a lot of people who have attorneys who've taken these courses and they tell me their attorneys are like, bless you. Like, wow. I'm not worthy, because they have all of their, like you said, the ducks in the row. They're gathering the information, they're organizing the information, and then they put it together and give it to the attorney. And this saves a lot of money, because there's nothing that costs more money than me getting a backpack full of crap that I have to go through and figure out what it is.
Yep.
So I have the 21-day challenge, and I also have the other course that I really like to promote is the trial prep boot camp. Okay. And in that, I teach people what to expect in the courtroom at trial, the order of things, and, who testifies first, what's going to happen, cross-examination, direct examination. And of course, nobody's going to be a lawyer after they take these classes, but they're going to know what to expect, which is one step ahead of where most people are when they get into this process, especially when they're alone.
Yes.
And as far as the divorce coaching, really, I'm doing the same thing, but I'm doing it on a one-on-one basis with people. And, we're diving into the specifics of their case. Mm-hmm. With the courses, they're very general, but I learn more about them and their situation and the facts of their case. And we brainstorm on what the best things are to be focusing on, and you kind of couple that, because I'm a very touchy-feely person. Mm-hmm. And, so there's some emotional support there with the divorce coaching that you wouldn't get with an online course.
Mm-hmm. Okay. I'm so excited about this, because I get that question a lot. Like, oh my gosh, I have my first trial hearing and I don't even know what to expect. What can I expect? And I'm like, I don't know. I never got that far. I had millions of them scheduled that were all canceled by my ex, but I never actually went to one. Okay. So here's another question. How can a woman prepare her children for a child-focused mediation?
Yeah. So, let me clarify that a little bit with you, Natalie, because that's foreign to me. When you say child-focused mediation, are you saying that the children are involved in the mediation? Because we don't have those here.
Okay. Well, so what we can do here, I'm in Minnesota, is you can have a mediation set up between you and your ex and the mediator and your attorneys, but to have the children represented and their issues represented, you get a neutral someone who's has experience in psychiatry or, something like a mental health professional who also maybe has court experience as well. And then he interviews the children and does a whole workup. And then he actually comes to the mediation as a representative of his findings.
Okay. So, and we have some permutation of that in different collaborative divorce, which I've also done in the past. And of course, in custody evaluations where the children are, may or may not be represented. There's different types of attorneys who can speak for the children or speak on their best interest. But if you have an attorney who is speaking for the children, as far as preparing the children, I think that it's important not to try to sway the children or try to sway them to say what you really want them to say or what you think that they want to say. It's just important to let them know that, mommy and daddy both love you so much and we want to spend as much time as we can with you. And we're just trying to work it out. And somebody, from the court is going to talk to you, and it's important to you. It's important that you just tell them the truth. You don't have to be afraid that anything's going to happen to you. And, and I don't know during your mediations, Natalie, or the child focused mediations, whether there's an admonition given that neither party is to, reprimand the children about what they might say, or if the children's voice is kept confidential or not. But I know for a lot of kids, there's a fear that one parent's going to find out and punish them.
Yep.
But, you have to just really tell the truth. We love you. You've done nothing wrong. We're trying to do what's the best for you, and just reassure them that it's going to be okay.
Yeah.
But by no means, tell them, write a letter about what you want. I would never do that. And I had a client who did it once and she got punished big time.
So make sure that you're not coaching your kids on what to say in any kind of a situation where they have any kind of a voice.
That's right. And, and it's a different thing if you have a 12-year-old who likes to write in her journal and then she gives you her journal or shares a letter with you. That's different than saying, okay, Joni, write a letter to daddy about what you want. Those are two different things.
Right. Okay. Yeah. All right. So, what if she loses? Like, what if the mother not loses custody, but let's say that they end up getting to have, 50-50. That would be like probably what she would consider a loss. What are her options after that? Is it just kind of like, well, I just need to accept it. Let's say that things continue to go downhill for her kids. And is there hope for her to actually go back and figure out a new way of dealing with things? Can she present new evidence? How does that work?
There is hope. And the good thing about child custody proceedings is that a decision is not necessarily forever, and you can modify a court's decision. You can't modify it probably next month, and maybe not even next year, but possibly next year. It depends. But what a judge is going to be looking at is a substantial and continuing change in circumstances and whether or not that's happened from the time that the decision was entered and whenever you're trying to make the change. So, a lot of times with these guys, they want power and they want control. And once they have it, then they move on with their lives and they're not exercising their time. That doesn't always happen, but sometimes it does.
Mm-hmm.
So say you get, an ex who wants his power, he gets his 50 time, but then he's canceling, not calling, not involved with the school, and different things are happening. Well, these are things that you can use because you're going to be documenting them now.
Right.
You can use in the future to ask the court to modify parenting time because dad is not exercising it. And, I will say when people go back to modify time, it's usually best if you have more than just one reason for asking the court to modify. It's rare that there's one smoking gun. If you have 2 or 3 things that have changed, that is more helpful. So say, dad not doing what he's supposed to, combined with maybe you starting a new family or the child having new step siblings or the child's not doing well in school or, so there's a lot of changes that can happen. A physical move, a residential move could be a change in circumstances. But I would recommend people looking for more than just one thing. Because if you go to court with just one thing, I don't know that a judge is going to find a substantial and continuing change.
Okay. And then I think my last question would be, a lot of the women that I work with have attorneys and some of them don't like their attorneys, but again, they kind of feel like they're the little girl, and everyone is their mom and dad. And the attorney kind of represents that authority figure in their life. And so they feel like, well, they're in charge. They must know what they're doing. But inside, they don't feel comfortable with what their attorney is doing. Maybe their attorney is not really doing much of anything. Their attorney's not really guiding them, in which case they can go take your courses and figure it out on their own, right?
Right.
So, but what should she be expecting? What's the minimum that she should be expecting from her attorney? And when would you advise her to let that attorney go? And what would that process look like to let your attorney go?
Yeah. So she should, at the very minimum, from day one, minute one, be expecting and demanding of respect. I've had so many clients who come to me and say, I want to hire you. And then they start telling me their attorney used to berate them, yell at them, tell them they were stupid. And I don't understand that. It's like, you are paying this person, first of all. And secondly, they're supposed to be helping you.
Right.
And so, if you ever get if anybody ever does that to you, they're not the right person, because they're not treating you with the respect that you deserve. It's just more abuse. Okay.
Yep.
And I would say if even once you're mistreated in that way, say bye-bye. And there's a difference between that though and tough love. I will say that, okay? Because sometimes I have to give my clients tough love, but I'm never disrespectful about it.
Yeah.
And I never name call. So that's one thing. So in terms of timing as to when to get rid of it, if somebody yells at you, calls you stupid or whatever, is just disrespectful, then get rid of them then.
Okay, so can I interrupt here just a second? So when you say get rid of, do you get your retainer money back that hasn't been spent yet? How does that work?
It depends on the contract and what your fee agreement says. But if you're being billed hourly and they haven't used some money, yes, then you're entitled to that money back. So I would want an accounting of everything that's been done to date and how much is left in the trust account, and I would want that back. They are required to give you your file, so they can't withhold your file. If you owe them money, they can't withhold the file from you. They have to give the file back to you. There's ethical rules that state that. So, I would say though, and sometimes bills I think are subject to dispute. Of course, that's the whole other issue with attorneys. You got to look at the bill and see in good faith whether they quote earn the money. And if you feel that they earn money, then if you can, pay them. But, so yeah, you're entitled to the money, you're entitled to your file.
Okay.
And, but in terms of timing, I've had friends and I've had clients or people who have other attorneys who tell me, I just am not getting a good feeling, or I don't feel like my attorney listens to me, or I tell my attorney one thing and then we go into court and the attorney says the exact opposite of what I told them. So I have a friend who's going through a divorce right now, and that's happening to her constantly. And I keep telling her, get rid of your attorney. So you have to trust your instinct. You have to listen to your gut. Your gut delivers valuable information. That's called your intuition. And the sooner the better, because the longer you go, the more difficult it is going to be to get out. It's like the gambler's dilemma. A gambler goes to Vegas and, they're losing money, at a table. And they keep throwing money at it thinking, okay, it's going to turn around. It's going to turn around. And then pretty soon they're $10,000, $20,000 in. And they feel like I can't get out because I've invested this much. It's the same thing with an attorney. So if your intuition saying, something's not right, or I don't like this, then get out and find a new attorney early on. There's a lot of attorneys out there. And, you have to find somebody who resonates with you and who's in alignment with who you are and what you want.
Is there a place where people can go to find a really good attorney? Like if someone is just completely starting out and they've only been thinking about divorce and now they're thinking, I want to go find an attorney. What would their first step be?
Well, there's a website called Avvo. It's avvo.com, and it's a ratings website for attorneys. And not all attorneys claim their profile, so I guess if an attorney hasn't claimed a profile, unless that attorney was referred to me by somebody I really trust, I probably wouldn't use that attorney. But you can look at Avvo and see what, people's experiences are with a certain attorney. I would also look at Google. That's, Google reviews are a good source of information. That social proof. Really look at what other people are saying.
Yeah.
And then, of course, so those are two places to start. And I always think like referrals are great. If you have a friend that you trust or a friend of a friend that you trust, see if they can recommend anybody. If you know an attorney, any kind of an attorney, not just a family law attorney, if you know a real estate attorney or a landlord tenant attorney, I bet that attorney knows somebody that they trust. So it's, not settling for the first person or the cheapest person, but the person who you think is going to do a good job and that resonates with you.
Right. Okay. That's great. All right. So we talked a little bit about what you do and what you have to offer. So I just want to encourage anyone listening to check out Command the Courtroom, her Command the Courtroom YouTube channel for sure, just to get more of a taste of this is a podcast. So your people might be seeing this, but my people are just hearing you. so that you can see her and, like get a feel for who she is and what she has to offer you. And then you can also go to her website and get on her mailing list. And she gives you lots of value on her mailing list as well. And what's your website URL again?
It's commandthecourtroom.com.
Oh, so easy. So go do that, get on her mailing list and check out her website, because that's where you can see what the products that she has to offer, the help that she has to offer for you. And I think ultimately this is going to save you a ton of money, because it's going to set you up with the knowledge and the skills and all of the stuff that you need to do ahead of time. So like she said, you can bring all of this stuff to your attorney. Your attorney doesn't have to wade through everything, because everything that your attorney and their paralegal do for you is billable. So why spend money on that? Why not just do it yourself? Present your case to your attorney and then make it super easy for them. Plus, they'll really love you for it, it sounds like.
That's right.
And
totally.
You'll get off on a really good foot with your attorney.
For sure.
So, that's great. Is there anything else that you wanted to share with this audience before we close?
Natalie, I'll just say, when where kids are concerned, the judge is always going to be thinking about the best interest of the kids. So above all, and I know all the ladies out there that are your followers are thinking about their kids first. Just keep that in mind, but there's specific legal factors that the judge is going to look at. So when they go to commandthecourtroom.com, I have a best interest checklist where I went through several years ago and outlined the best interest factors from every single state. And so there's a comprehensive list of every factor, and they're not organized by state, they're just in one big list. But your ladies can know what factors the court is going to look at and which factors apply to their case. That's free at commandthecourtroom.com. So I just wanted to share that. And I also wanted to thank you for being such an awesome host and inviting me to be on the show.
Thank you. There's so much for giving us your time, sharing your time with us.
You're welcome.
And for the rest of you, thanks for listening. Until next time, fly free.